an act of culpable homicide defined under section 299 falling with one or more of the classes given under section 300 is murder. And if that murder is committed in any of the circumstances that are mentioned in the general exceptions, is not amounting to murder. I think you can understand this seeing this. Section 299 is the culpable homicide. It has three classes, A, B, C. It has three classes, A, B, C, and three explanations. 299 consists of three classes, A, B, C, and three explanations. And section 300 consists of four classes and five exceptions. Consists of four classes and five exceptions. Now, culpable homicide, which is defined under section 299, if it falls any one of the class that is mentioned under section 300, then that culpable homicide would amount to the murder. Culpable homicide, that is 299, when it amounts to the murder, 299 plus any one of the class, one or more of the class given under section 300, then this culpable homicide 299 would amount to the murder. So that is called as culpable homicide amounting to murder. Culpable homicide amounting to murder. And if the murder is committed under the circumstances falling any one of the five exceptions, so murder plus any of the circumstances falling any one of the exception, that is called culpable homicide not amounting to murder. Not amounting to murder. So thus it includes when culpable homicide amounting to murder, when the culpable homicide not amounting to murder can be, you should have a clear idea. You should have a clear idea. 299 plus any one of the class that is given under section 300, then 299 would amount to the murder. If that murder is committed in any one of the circumstances mentioned in the five exceptions, then it would amount to the not amounting to murder. It was held in the case of Narsingh Chalan vs. State of Orissa, 1997, and Abdul Wahid Khan vs. State of AP, 2002. The Supreme Court held that section 299 is the genus and section 300 is the species. There is an independent section to the section 299, culpable homicide, there is an independent section. Culpable homicide amounting to murder, that is the murder, has an independent section, but culpable homicide not amounting to murder, there is no independent section. There is no independent section because it is a part of section 300. Culpable homicide not amounting to murder is a part of section 300. All the five exceptions given under section 300 are culpable homicide not amounting to murder. So where are these five exceptions? These five exceptions are in section 300 only. So there is no separate section. The court observed that for deciding the proper punishment, which is proportionate to the current offense, IPC has divided culpable homicide into 3 degrees. To inflict a proper punishment, the Supreme Court said that the IPC divided the culpable homicide into 3 categories. What are they? Culpable homicide first degree, it is the gravest form of 302 IPC, that is murder. Murder is the gravest form of culpable homicide, that is the first degree. It is punishable under section 302 IPC. That is murder. Second, culpable homicide of second degree, it is punishable under section 304 part 1. Part 1. And culpable homicide third degree is punishable under section 304 part 2. See, highest degree, first degree, gravest degree is punishable under section 302, that is the murder. Culpable homicide of the second degree is punishable under section 304 part 1. And the culpable homicide of the third degree is punishable under section 304 part 2. Now let us see what is the culpable homicide of the first degree. So this is very simple. This is the gravest form. It is defined in section 300, that is murder, provided punishment under section 302. What is the punishment? Death or life imprisonment, to either of which fine may be added. So murder is the gravest form. Now, what is the second degree? Culpable homicide of the second degree. It states, if the act by which death is caused. So a person committed an act. Because of that act, he caused the death of the person. And he is done with the intention to cause death or intention to cause bodily injury as is likely to cause death. That is, these two falls in section 299A and B. Section 299A deals with the intention to cause death. B deal with intention to cause bodily injury as is likely to cause death. They are punishable under 304 part 1 of the Indian Penal Code. What is the punishment? Life imprisonment or an imprisonment up to 10 years, to either of which fine may be added. The lowest degree, the third degree, that is where the accused had a knowledge. Both first two are intention. First degree, second degree depends on intention, but the third degree is a knowledge, that type of second type of mens rea. Here the accused had a knowledge that by doing such act, that act is likely to cause death. Is likely to cause death. That is section 299C falls under this category. 299C, which is punishable under section 304 part 2 of the Indian Penal Code. So this is the background of culpable homicide or murder, etc. Now we'll go into the specifically the offense of culpable homicide under section 299, what the definition given under culpable homicide. When it should amount to the culpable homicide? What are the ingredients required to complete the offense of culpable homicide? So section reads, whoever causes death by doing an act. Whoever causes death by doing an act with the intention of causing death or with the intention of causing such bodily injury as is likely to cause death, or with the knowledge that is likely by such act to cause the death. So just now we have seen first degree is the murder, second degree is with the intention of causing death or with the intention of causing such bodily injury as is likely to cause death. These are A and B. Class A and B of section 299 falls under 304 part 1. And this third, with the knowledge that he is likely by such act to cause the death, this is the third degree of culpable homicide, lowest degree of culpable homicide. So whoever causes death by doing an act with the intention of causing death or with the intention of causing such bodily injury as is likely to cause death, or with the knowledge that he is likely by such act to cause the death. So what is the mental element required for the culpable homicide? Two mens rea, intention and knowledge. Both are required. Either of them should be present. Then we can say that it is a culpable homicide. There are three illustrations given under the section. I will give only one. A knows that Z is behind the bush and B doesn't know that Z was there. A had an intention to kill B, so he induces the B to fire at the bush. So B fires at the bush, the Z dies. B has committed no offense. He is not guilty of any offense because he doesn't have any intention to cause death. He does not have any intention to cause bodily injury. Even he does not have the knowledge that Z was behind the bush. So B is not guilty of any offense, but it is the A is held guilty for the culpable homicide. So these are the illustrations given under section 299. And there are three explanations given under section 299. What is the explanation 1? A person who causes bodily injury to another, who is laboring under a disorder, disease or bodily infirmity, and thereby accelerates the death of that other, shall be deemed to have caused the death. So the explanations one says about the causation of death. Death can be caused in this way also. This is also a causation of death. What is it? B is suffering with either disorder or disease or bodily infirmity. B is suffering with any one of these. A inflicts a bodily injury on the B. A inflicts bodily injury on the B. And here B, because suffering with some infirmity, disorder or disease, he dies. A is held guilty of culpable homicide. This is also a causing the death. Causation of death. This is also one of the way of causing the death. So B is suffering or laboring under some disorder, disease or bodily infirmity. He had something problem with the health. A inflicts the bodily injury on B. And B dies because of the defect in the health. Just for the bodily injury inflicted by A, he dies. This is a culpable, this is all homicide, and this is also causing the death of the person. What is the explanation 2? Where death is caused by bodily injury. By inflicting the bodily injury, A inflicted a bodily injury and B dies. The person who causes such bodily injury shall be deemed to have caused the death. That is, A inflicted the bodily injury and B dies. Here what it says, A caused the death of B. Although by resorting to proper remedies and skillful treatment, the death might have been prevented. A inflicted a bodily injury on the B. If B goes to the hospital and gets a proper treatment or a skillful treatment, definitely the death might have been prevented. But the B did not do so. He did not take the treatment. B dies. A has no defense to say that if he would have been gone to the hospital, and if he took a proper treatment, the death might have been prevented. All these defenses are not acceptable. He causes bodily injury and he dies. Whether he goes to the hospital, whether he takes a proper treatment or not, these are all irrelevant. A causes the death of B. This is the explanation 2 says. So first explanation, again I am repeating because this is the point where it makes the differences between the culpable homicide and murder. So I am again repeating the explanation 1, that where A inflicts a bodily injury on a B. A inflicts a bodily injury on B and B is suffering with some disease or disorder or bodily infirmity. Because of defect in the body, because of ill health of B, just because of bodily injury inflicted by A, B dies. A causes the death of B. A causes the death of B. So he was in ill health, he was not in a good health position. These are all not to be accepted as a defenses to the A. A has caused the death of B. Similarly, A inflicted a bodily injury on the B, but B has not taken a proper treatment or a skillful treatment. He has not gone to the hospital. He died. And if A says that if he would have been gone to the hospital and took a proper treatment or the skillful treatment, the death might have been prevented. All these not are acceptable. A caused the death of B. Third explanation. The causing the death of the child in the mother's womb is not homicide. The child is in the womb of the mother, not delivered. Still the child is in the womb of the mother. If the child kills in the womb itself, it is not a homicide. This is some other offense, that is miscarriage. Miscarriage, that is a different offense, but it is not an homicide. When it becomes the homicide, amount to culpable homicide to cause the death of a living child if any part of that child has been brought forth, though the child may not have breathed or been completely born. So these are the 3 explanations. There are 3 clauses A, B, C and 3 explanations contains in section 299. This is culpable homicide. Now let us go, this is a verbatim of the section, what is given under section 219. Now go to the, what are the ingredients required to the culpable homicide. There are 3 elements to constitute the offense. For any offense, 3 things. One is the physical act, mental element and consequence. These 3 must be there. What is the consequence in the homicide, culpable homicide? Death. Causing the death of a human being. Causing the death of a human being is the consequence. How to cause the death of a human being? By doing an act. That is the physical act. So causing the death of a human being, death is the consequence. How he will cause the death? By doing an act. By doing an act, A is causing the death of B. By doing an act, that is the physical act. And third is the mental element. What is the mental element? Either he should have an intention of causing death or intention of causing such bodily injury as is likely to cause death, or with the knowledge that he is likely by such act to cause the death. So intention and knowledge is the mens rea. Intention and knowledge is the mens rea. So what are the ingredients? The causing the death of a human being by doing an act, and mental element is 3 things. Intention to cause death, intention to cause bodily injury as is likely to cause death, or the knowledge that he is likely by doing such act causes the death. So these are the 3 essential elements required to constitute the offense of culpable homicide. Now take the first ingredient. What is the first ingredient? Causing the death of a human being. Causing the death of a human being is the first and the essential ingredient required for the offense of culpable homicide. Death means death of a human being. Defines under section 46 of the Indian Penal Code. Life means life of a human being. Defined under section 45 of the Indian Penal Code. If you look into the second chapter of the Indian Penal Code, it contains all definitions only. Second chapter of the Indian Penal Code contains all definitions, and these definitions, death and life, also found there only under section 46 and 45. The definitions that are defined under chapter 2 are applicable only to the Indian Penal Code. These definitions are not applicable to any other law. The definitions are applicable only to the Indian Penal Code. Here the death means death of a human being, the definition given. So this definition is applicable only to the Indian Penal Code. Life means life of a human being. So this definition is applicable only to the Indian Penal Code, not any other laws. And causing the death of a human being. Now the question is, who is a human being? Explanation 3 has to read here. What is explanation 3? It includes the death of a living child. It includes the death of a living child. When? If any part of that child, has been brought forth, or any part of the child emerged from the womb of the mother, or any part of the child is delivered, any part is sufficient, leg, head, hand, any part of the body, if emerge from the womb of the mother, and if though the child has been breathed or not completely born, at this stage, if any person kills that child, it is a culpable homicide. Culpable homicide. So, it means the human fetus is not a human being. Human fetus is not a human being. Because as long as the child, even the fully developed child also, in the womb of the mother itself, it is not a human being. Even the fully developed child in the womb of the mother is not considered as a human being. If he kills a child in the womb of the mother itself, it is not a culpable homicide, it is a miscarriage. It is an offense of miscarriage. So what is required? A child must be partially born, partially developed, partially delivered from the womb of the mother is required. Then only that child will be considered as a human being. Now there is a difference between the English law and Indian law. In English law, the child must be completely born. Then only the child will be considered as a human being. But in Indian law, a partly delivered child is sufficient. Now who are the human beings? Because causing the death of the human being is an essential condition. Causing the death of a human being is the essential condition. So who are the human beings? A living man, a living woman, and child at least a partially delivered. Why we are saying living man or living woman? So killing the dead person is not a homicide. A stabs B. B died. Later X came with an intention to kill B, fires at B. Because he killed the dead person, dead body. So the X is not guilty of culpable homicide. It is only the A held guilty. Suppose A got a heart attack and died. X had an intention to kill A. He entered into the room and he was under the impression that A was sleeping on the bed. He fires at A. Because his A is already dead. A is already dead. So it is not a culpable homicide. So human being means a living man, living woman, and a child at least partly developed, partially delivered, are to be considered as a human being, and killing of such persons are only considered as a homicide. So this is the first essential ingredient causing the death of a human being. Who are the human beings, etc. Second ingredient, doing an act, that is actus reus, or the physical act. An act may be said to cause death. So A did an act, that act causes the death. How to say? An act may be said to cause the death when the death results from the act. So A did an act, the death results from the act of A, or the consequence naturally flows from the act or flowing from the act. We can say simple words. We can say in other way also. The physical act and the consequence death must have a direct link, connection. Then only we can say that act is said to be caused the death. The physical act and the consequence. A stabbed B, B dies. The consequence, that is the death of B, flowed from the physical act of A, that is stabbing. Stabbing. Or A pulls the trigger. The bullet leaves the gun and enters into the body of B and B dies. So there is a link, direct connection between the physical act and the consequence. This link is very, very important. Not only to the homicide, for any other offense, it is the duty of the prosecution. The prosecution must establish the link between the physical act and the consequence. Even for theft, forgery, cheating, any offense, not only to the homicide, there must be a direct link between the physical act and the consequence. The burden lies on the prosecution. The prosecution has established the link, then only the accuser is liable. If the prosecution fails to establish the link between the physical act and the consequence, either the accuser will be discharged or will get the benefit of the doubt. And the death must be proximate, very close to the act of the accused. If it is remote consequence of violence, then it is not a culpable homicide. That is causa causans. That is proximate, very close. He pulled the trigger and he died. He stabbed and he died. Proximate, very close. So causa causans, immediate, proximate, but not the causa sine qua non. Means necessary cause, remote cause. They are not taken into consideration. And now, what are the modes of causing the death? Act. Here we are doing an act. What type of act he has to do in order to kill a person? There are variety of modes of causing the death. Starvation, striking, stabbing, pulling the trigger, giving a poisonous food, pouring a petrol and setting the fire to the body. Still there are many other ways of causing the death. But death can be caused by words also. Not only by doing the act, death can be caused by words. If the death is caused by words deliberately used by a person with the intention or knowledge of causing that result, the person shall be liable for culpable homicide. Suppose A is a heart patient. Doctor gave a strict warning not to communicate any type of shocking news to him. A, with an intention to kill him, knowingly, deliberately, he rushed into the room and says to the A that all your family members were died on the accident. So, he will get shocked and collapsed, died. So, with the words also, death can be caused. The tongue has the power of life and death. Can do, not only knife is not necessary, or a pistol is not necessary, or a gun is not necessary, poison food is not necessary. Even with the mere words also you can cause the death of the person. The tongue has such a power. So the same result may be achieved by an act accompanied by a transmission of force, such as making a loud noise before the sick person to awake him when sleep is most essential for his living. So, by doing all these things, culpable homicide can be committed. Not only the stabbing or physical act, even with the words also, death can be caused. Not only that, death can be caused by omission also. Omission, not only by doing an act, stabbing, giving the poisonous food, etc. By omission also, through omission also, death can be caused. If you look into the section 33 of the Indian Penal Code, it defines act. Act includes illegal omission. Specifically, they used the word illegal omission, which means all omissions are not punishable, or all omissions are not included in the definition of the act. Only the illegal omission. What is illegal omission? When you can say that omission is an illegal. In criminal law, omission is also an actus reus, because of the definition given under Indian Penal Code section 33. If you read section 33, act includes omission, illegal omission. So, criminal act, omission is also an actus reus, not only the physical act. Physical act includes omission also. What is illegal? When that omission will become an illegal? Means a legal duty is imposed on a person and the person has failed to fulfill that obligation. A legal duty imposed on him. A legal duty is imposed on a person and that person failed to fulfill that obligation. That is, he omitted, he did not perform. There is a breach of duty. Then such omissions are called as illegal omissions. I will give an example. What is the duty of the police officer? The duty of the police officer is to maintain law and order. Prevention of the crime. This is the main duty of the police officer. If he did not do so, A rushed to the police station and said to the police officer that B is going to kill C. The police is not bothered. He is not moved an inch. He had omitted his duty. That is called illegal omission. So first you have to prove there must be a legal duty on the person. and he did not fulfill the obligation. For example, you take section 125 of the CRPC. Section 125 CRPC imposes a duty on the husband to maintain the wife. The parents have to maintain their children, and the children are to maintain their parents. It's a legal duty. This is a legal duty. They must maintain their parents. They must maintain their children. The husband must maintain his wife. If the parents fails providing food to the children, and if the children died because of starvation, the parents are liable. They have committed the culpable homicide. They have committed the culpable. There are a number of illustrations. Nurse duties to give a medicine to the patient to the scheduled time. Jailer. There are number of duties are imposed on the persons, and if they fail to fulfill, they are liable to be punishable. So death can be caused not only by doing an act, but by illegal omission also. So from all these illustrations, it is very clear that death can be caused both by doing an act as well as by illegal omission. These are the cases, Gibbons versus Proctor. Here the parents are failed to cause the death of their child by starvation. So the parents are held guilty for the offense of murder. Pittswood case. So what is the duty of the gateman? The gateman is to close the gate whenever the train approaches. Suppose if he did not close the gate while the train is coming, suppose if the person while crossing the track, he hit the rail and caused the death. Here the gateman is held responsible for causing the death of the person, because he failed to perform his duty. What is his duty? He has to close the gate. He did not do so. It is an illegal omission, and he is liable to cause the culpable homicide. He is held guilty for the offense. He is responsible for causing the death of the person. He did not stab him. He did not pull the trigger. Nothing he did. But still, by failing to perform his duty imposed by law, legal duty, there was a contract of employment between the gatekeeper and the government, and the breach of contract is there, causes the death of the person, the gateman is held responsible. Nichols, she is an old woman, failed to provide a medical aid to the infant grandson. So the old man is held guilty for the offense of manslaughter. What is a manslaughter? It is called culpable homicide in Indian Penal Code. Manslaughter is an offense under England. Manslaughter, man cut, manslaughter. That is equivalent to culpable homicide in India. Stone and Robinson case. So far we said that when omission would become the illegal, first condition is there must be a legal duty on the person. Legal duty on the person, and he failed to fulfill that obligation. Then he is responsible. Now, a person is going in the early hours on the road, found an infant by the side of the road. He has not taken the child into his hand, into his custody. He went away. The child dies. The person is not responsible, because it is not the legal duty. It is only the moral duty. It is not the legal duty. But once suppose if he took the child into his custody, then legal duty starts. If any failure on his part and if the child dies, he is responsible for causing the death of the child. Amounts to the culpable homicide. So if anybody takes an orphan child into their custody, then duty starts. But it is not necessary to take the child into their custody. Once taken, the duty starts. So these are the examples of illegal omission. So act includes illegal omission. So death can be caused by doing an act and at the same time by illegal omission also. The other point, the offense is complete as soon as any person killed. See, any person. The offense is completed as soon as any person is killed. That is, A have an intention to kill B, but he kills C. either accidentally or negligently. The law says it is immaterial. Law says it is immaterial. If the person whom the accused intended to kill was not killed, but killed some other person. So this principle was incorporated in section 301 of the IPC. If you read section 301 of the IPC, you will find this principle. And this is not a new piece of legislation. This is dated back the British era. That is, Indian Penal Code is drafted in 1860 by Lord Macaulay. So this 301 was incorporated by Lord Macaulay in 1860. So this is a very, very, very old principle. This is not a new legislation. So a person having an intention to kill B, but he killed C. It is immaterial, not taking into consideration. What is required is kill any person. Offence is completed as soon as any person is killed. That is, this is called as a doctrine of transfer of malice. Doctrine of transfer of malice. That is, A have an intention to kill B, but killed C. So the intention is transferred to C, whom he did not intended to kill, from the person to whom he intended to kill. That is called transfer of malice, transfer of intent, transfer of knowledge. This is called as a doctrine of transfer of malice. Malice is a English word that is equivalent to the intention. Malice aforethought is the essential ingredient or the mental element required for completion of the offence of culpable homicide in England. So we are calling it the intention or knowledge. And this is the case R versus Latimer in 1886. Here a person got into a fight, and in the course of the fight, to beat the man, he took out of his belt and struck the belt, but it rebounded and hit a lady, and she was grievously injured. What are the facts of this case? A fight was started between the A and B. A wants to beat the B. During the course of the struggle, B wants to beat the B. So he took a belt and struck the belt, but it rebounded the lady who was nearby and hit the lady, and she was grievously and seriously injured. He wants to beat B, but it hit the woman. The court held that the defendant is held, the accused is liable, the defendant or the accused is liable for inflicting the injuries on the woman, ignoring the fact that he had no intention to harm her. Even though he did not have an intention to harm the woman, but still law considers that he is held guilty for causing injuries to the woman. So the mens rea is transferred to the woman. Here the mens rea is transferred to the woman from the man to whom he was going to hit with the belt. This is the physical act or the actus reus. So two ingredients we have completed. One is the causing the death of a human being, who is a human being, and act of the death act, that is the act can be caused either by words or by omission, illegal omission, in addition to that stabbing, poisonous food, etc., etc.